may proceed.
Thank you. Please tell the court your name and occupation and spell your name, if you would, please.
Carrie Roderick, and it's K-A-R is the first name, and then Roderick, R-O-D-E-R-I-C-K. I'm a missing persons investigative analyst for the Sheriff's Office.
Okay. You are a civilian employee, not sworn, correct?
Correct.
Did you work on the investigation into the alleged disappearance of Kaylee Marie Anthony commencing back in July of 2008?
Yes, ma'am.
Okay. Were you an individual who was under the supervision of Sergeant John Allen at that time?
Yes, ma'am.
If I may approach the witness with Exhibit 4 Exhibit 4 in evidence.
You may.
Were you asked to complete an investigative cost expense report that would detail your hours involved in this investigation?
Yes, ma'am.
Okay. Can you tell the judge what responsibility you had under Sergeant Allen's supervision?
I entered the leads and tips that came in for the case. I also assisted with the EquiSearch when they were there and taking calls that were coming in with tips and leads and filling them out and handing them off to others to go out in the field to search, follow up on.
How many tips or leads did the Orange County Sheriff's Office receive, approximately, that you were responsible for organizing and distributing?
About 1,600, if I remember correctly. I know it was in the thousands.
All right. Did you also have regular contact with an individual by the name of Cindy Anthony, who would provide leads and tips and information to the Orange County Sheriff's Office?
Yes, ma'am. She emailed me directly.
Okay. I'm going to show you a sheet that purports to have your signature at the bottom.
Yes, ma'am.
Is that in fact your signature?
Yes, ma'am.
Did you affix your signature to that document on 7/27/2011?
Yes, ma'am.
At the top of that worksheet, it has dates, July 16th through July 31st of 2008. Did you work during a time frame longer than July 16th to
Yes,
July
ma'am.
31st? How long did you actually work on this?
Till at least the end of December.
Of 2008?
Yes, 2008.
All right. So the July 31st of 2008, is that a typographical error?
Yes, ma'am.
Did you in fact work 1,106.5 hours assisting the investigators into locating Kaylee Marie Anthony?
Yes, ma'am.
Cross-examination.
Ms. Roderick, can you recall when you were asked to go in to see Lieutenant Zamboros?
Zamboros, yes, sir.
And you recall having a conversation with him about your work hours?
Yes, sir.
And you recall why he had you in there to do that?
To fill out the form.
For the purpose of what?
To turn in.
Do you know why?
Well, for the cost of I didn't know the purpose of what he was doing with it now, or where he was turning it into now.
Did you fill out that document yourself?
Yes.
Well, it's not. I mean, you put the form in a typewriter and typed it yourself, or a computer or something?
Correct. Computer.
And the numbers on there, they're in handwritten. Did you do that?
At the bottom?
Yes.
Yes.
So you didn't just make a typo once. Let me approach it.
You may.
I should have probably put it away. That's okay. You made a mistake of your saying as to the dates of work.
Correct.
Yes?
Correct.
And you typed the hours at the top line.
Correct.
You typed the hours on the total hours.
Correct.
And then down here in handwriting, you handwrote.
That's not my handwriting.
Well, that's not your handwriting.
No.
But that is your signature.
That's my signature. I did this part up here, and I signed right here.
And did you keep a copy of this?
I just turned it in.
You knew there was some significance to that, did you not?
Yes.
And so, would I be correct, ma'am, that the first time it's been called to your attention was within the last hour and a half?
Correct.
Nothing further, Your Honor.
Any redirect?
No, Your Honor.
May the witness be excused?
Yes.
Thank you, Mrs. Roderick. You may be excused, ma'am.
Thank you.
State, we call in next witness.
John Allen.
I do.
You may proceed.
Tell the court your name and occupation.
My name is John Allen, and I'm sorry, I'm sick. I'm a sergeant with the Orange County Sheriff's Office.
Do you have a specific assignment, or let me go back. Did you have a specific assignment with the Orange County Sheriff's Office back in July of 2008?
Yes, ma'am, I did.
What was that?
At that time, I was assigned as the supervisor of the Missing Persons Child Abuse Squad.
As a result of that assignment, did you become involved in the investigation into the alleged disappearance of Carrie Marie Anthony?
Yes, ma'am, I did.
As the sergeant of the Missing Persons Unit, were you supervising and directing the activities of various members of the Orange County Sheriff's Office into locating Carrie Marie Anthony?
Yes, ma'am, I did.
We were also involved in having some conversation with Casey Anthony at Universal Studios on July 16th of 2008.
Yes, ma'am, I did.
Okay. During that conversation, did Ms. Anthony continue to maintain that she had left her child with a Zenaida Fernandez Gonzalez in June of 2008, and that this person had failed to return her child?
Yes, ma'am.
As a result of that and the other lies that Ms. Anthony told, did you cause members of the Orange County Sheriff's Office to attempt to look for Kaylee Anthony and determine what really had happened to her?
Yes, ma'am.
Have you had the opportunity to review a spreadsheet that contains the various hours of activity for different subdivisions or subsections of the Orange County Sheriff?
Yes, ma'am, I did so in the deposition the other day.
If I may approach the witness with Exhibit 4 in evidence.
You may.
That summary is divided into half a dozen or more sections, correct?
Yes, ma'am, it is.
The first section there is the missing persons section.
Yes.
Can you detail for the court what activity the missing persons section took as a result of the lies for which Ms. Anthony was convicted?
Yes, ma'am. William Melich, he was the lead investigator assigned to the initial report of the kidnapping or abduction of Kaylee Anthony. Tanya DePalmo, Carrie Roderick, Wilda Gonzalez, and Wilda McBride and Kelly DeGuzman. At the time, they were all assigned to missing persons. We set up a database, whereas the leads came in from across the country, and they were tasked with entering those leads into that database and ensuring that as as they were assigned to different personnel. We would assign all of the local leads to members of the Orange County Sheriff's Office, people either in homicide or the domestic violence squad or various other squads that chipped in to help out. Any of the leads that came in that were out of the local area within the state, there were more than 40 FDLE agents that would follow up on those leads. And of course, the out-of-state leads, the ones that weren't immediate leads, they would go to the FBI, and at different times they had more than 100 FBI agents following up on more than 6,000 leads that come in. Tanya, Carrie, and Awilda and Kelly had to ensure that all of those leads, as they came back in, were cataloged into that system.
Right. How many leads did the Orange County Sheriff's Office catalog as a result of what Ms. Anthony had said?
Just the ones that came into to our squad. This would not count. A lot of these would come into the comm center, and deputies would be dispatched. We weren't really able to track that, but just the ones that came through our office totals 6,165.
You had indicated that there were other squads besides the missing persons squad that chipped in to help do leads follow-up within the confines of Orange County, I imagine. Are those individuals also reflected on that spreadsheet?
Some of them are. As I look at the list, I recall everybody on this list at one time or another, the detectives been given leads, but I don't know that we were able to capture the total amount because information was coming in at such a at a volume that was difficult to keep up with on a daily basis.
Okay. After the missing persons section on that spreadsheet, there is another section that deals with homicide, correct?
Yes, ma'am.
Right. Were those individuals assigned to homicide, investigating a homicide exclusively, or were they tasked with following up on leads or assisting Detective Melich in some fashion in trying to locate either Carrie Anthony or to evaluate the circumstances of her disappearance as reported by her mother?
All of these people at one time, at least early on in the investigation, as the leads were coming in, many of them were following up on leads regarding her being missing. At different times, leads would come in, and sometimes at a very high rate.
Okay. What other sections are on there?
Well, there's also the domestic violence child abuse squad. Later, when CID reorganized, child abuse went under domestic. At the time this admission came in, some of these people were assigned to child abuse missing persons. But all of the people in that section, Appy Wells, Carla Willis, Pedro Rivera, Mick Kishford, and the like, were following up on leads as they came in as it related to the abduction, the kidnapping of Kaylee Anthony.
Okay. Is there a section for forensics?
Yes, ma'am, there is.
Okay. Do you have knowledge as to what role forensics played in the investigation that commenced as a result of Ms. Anthony's lies?
Prior to the body being located in December, there were searches done, and of course, as a result of the search, we had to send forensics people out to collect evidence, clothing, bones that related to determining the animal bones. So they responded out during some of the search operations to collect evidence.
Right. They also processed evidence that was collected regarding Ms. Anthony's car or things at her residence in an effort to determine the truth of what happened to Kaylee Anthony after having been lied to by Casey.
Right, after she told us, after the initial interview where she told us about Zanny the nanny and the trip to Universal, we towed the vehicle in and began processing it for evidence. And we made a number of trips to the house where we collected evidence as well.
Okay. any remaining sections on the spreadsheet that you have knowledge of the activities of those employees of the Sheriff's Office?
Yes, ma'am. You have the sex crimes, people involved in sex crimes, more or less the same. They were involved in following up on leads at different times. I know at one point, Mike Seagraves, who was a corporal in there, he had to organize, canvas details where we would go out and knock on doors. And some of the detectives from all of the sections would participate in those canvases where we would knock on doors within the neighborhood or the apartment complex or different places where we would have sightings or the like in an attempt to locate Carrie Anthony. And then of course Sandra Osborne is listed on there who's assigned to computer crimes. She and Sergeant Kevin Stinger, of course, prior to the body being located, they did some forensic analysis on phones and computers for us.
All right. May I follow up with that? Are you speaking not only of any computer activity, but cell phones of friends or acquaintances of Ms. Anthony's that may lead to some information regarding the location of Kaylee Anthony?
Yes, ma'am. Computers and cell phones, we took a number, certainly early on, as we continued to look for a live child, as we would prioritize these. Obviously, the leads related to sightings of a live child were priorities, and of course, we would have to get anything that had to do with a cell phone or computer that might lead to finding her safely. That took a priority. We had some light duty people listed up there, Melissa Harrelson and Mark Whitener. They helped out with the leads come in. Like I said, it was over that short period of time, there were a number of leads come in. We had light duty people that help answer the phones and take the information. They were helping with that. And then, of course, Jason Forgy, he is a canine handler. And as we would go out early on, if we got a lead that required a search for the dog, Jason and Sergeant Brewer from the Essex County Sheriff's Office would help with that as well.
All right. Some of the tips or leads that you were receiving from interested persons had to do with areas of disturbed earth or bones that were recovered that somebody thought might have something to do with locating Kaylee Anthony.
Yes, ma'am.
Thank you, Sergeant. Your Honor, I have no other questions of the witness at this point.
Cross-examination, Mr. Mason.
Thank you, Your Honor. You worked very closely with Detective Jerry Millis, did you not?
Yes, sir.
When was it that you and he decided that this case was no longer a missing person case, but in fact a homicide case?
Well, we actually stopped following up on leads that involved live sightings. It would have been around September the 30th.
And I can't remember who all testified to what in this trial. Yes, I remember Detective Millis telling us that. Did you testify in the trial to the same thing?
I testified in trial regarding some evidence that was collected from some of the private investigators.
So as of September the 3rd of 2008, prior to the indictment by about 2 weeks,
yes,
you all had decided this was no longer a missing person case, but in fact was a homicide.
At that particular point in time, we had decided, that although we continue to look for her remains, we continue to follow up on any leads that would have led to her body being discovered. September the 30th, we've gotten evidence back that indicated that she was deceased.
And I don't know the answer to this question. I'll ask you anyway. Did you testify before the grand jury?
No, sir.
You are aware that the grand jury indictment was on October the 14th,
Yes, sir, I am.
some 2 weeks after you all had made the determination.
Yes, sir, that's correct.
And on October the 14th, the indictment charged Casey with first-degree murder
Yes, sir, they did.
and 4 counts of lying to Detective Melich.
Yes, sir.
Okay. And you all determined as investigators that in fact Casey and Marie Anthony had lied about working at Universal Studios during 2008.
Yes, sir.
You knew that, in fact, on July the 16th when you went out there, did you?
Yes, sir. When we went there, we knew that she didn't work there.
And you knew from the evening of July the 15th that, and the 16th in verification with management, that no one had been living in apartment 210 at Sawgrass Apartment for some time, did you?
I believe it would have been the morning of the 16th, Detective Melich spoke with somebody from the management of Sawgrass Apartments.
So, as to count 5, you all knew that statement was false, and you knew that conclusively by the morning of the 16th of July.
We knew conclusively that morning that nobody lived there. Clearly, we did not. It was clear to us that she hadn't been truthful. Yes, sir.
And by another day's investigation, you learned that no fictitious person by the name of Zenaida Fernandez Gonzalez or Gonzalez Fernandez or similarly had ever lived there, did you?
I don't recall specifically when, in my conversations with Melich, I don't recall specifically when he told me that we knew that Zenaida Gonzalez, who had gone to the apartment complex and had been there to apply for an apartment, but I don't know when we knew specifically this Zenaida Gonzalez that we spoke with did not ever actually live there. I think it wasn't until we spoke with her by phone.
The one you spoke with, as a matter of fact, was not known to have anything to do with this case, was she?
She would, we determined that she was not a kidnapper, yes, sir.
And you determined, in fact, by showing photographs to Casey, right after you came out of Universal Studios, you had a photograph of a Zenaida Fernandez Gonzalez, among others.
We had several. She looked at several photographs.
Casey didn't identify any of them.
No, sir, she didn't.
And you talked with management at Sawgrass and knew that no such person by any combination of name had ever lived at Sawgrass, didn't you?
Yes, sir, we did know that. I don't know the specific date we knew that.
Well, you know that you and or Detective Melich talked to the management people at Sawgrass on the following day.
Yes, sir.
Okay. And you knew also from talking to Casey that there was no such person as Jeffrey Michael Hopkins and Juliet Lewis, didn't you?
I'm sorry?
You knew from talking to Casey that there was no such persons as Jeffrey Michael Hopkins and or Juliet Lewis.
I don't know that we knew that from talking to Casey. I think what occurred was as investigators went, is she would tell us different, as she would provide different pieces of information, we wouldn't find out from her that it was a lie. We would find out from talking to others. And on that, with respect to Sawgrass, I don't know that I fully answered your question there. We did go to Sawgrass on the 16th, but we did go back later at different times. Some of the information I can't recall specifically. We had to subpoena the information.
Within days.
Yes, sir. Yes, sir. It would have been within a short period of time.
And just as you learned in one day that Casey did not work at Universal Studios, you learned from the same source that no Jeffrey Michael Hopkins or Juliet Lewis worked at Universal Studios too, didn't you?
Yes, sir.
And that was all learned right then in July of 2008?
It would have been in July, yes, sir.
And you also knew, as to count 7, that Casey had not received a phone call from Kaylee.
Count 7 being one of the...
I'm sorry. That you received a phone call from Kaylee on July the 15th at approximately 12 p.m.
I think that was determined by looking at phone records. Was
early on.
It would have been early. I can't give you a specific date, but yes, sir.
Thank you very much, Your Honor.
Any redirect?
No, thank you, Your Honor. No redirect.
May Sergeant Allen be excused.
Yes.
Thank you, Sergeant.
Thank you, Your Honor.
Ms. Burdick, any more witnesses, ma'am?
No more witnesses on these issues, Your Honor.
Defense, any witnesses?
No.
Argument, state, then defense.
Your Honor, as I had mentioned earlier, I provided a packet of case law to the court. The bulk of the case law at the beginning, particularly the cases out of Florida, have to do with the admissibility of evidence, obviously, in a restitution hearing, how reliable any hearsay evidence has to be before it's admissible, who can testify to various aspects of costs and expenses. Those items have already been introduced into evidence without objection. The only other point to be made by those cases is the consistent statement that the state's burden of proof in order to support an award of restitution or cost of investigation or cost of prosecution is that those items need be established by a preponderance of the evidence. I don't believe that we're going to have any dispute between us as to the legal requirements. I could find no Florida case that talks about the apportionment of costs in a criminal context when an accused is convicted of some of the counts and acquitted of others. My research in that regard led to very little case law in the entire United States. However, there are a few out-of-state cases that I have included with the packet that give some guidance, I suppose, although I could not find anything, obviously, as unique as the circumstances that the court faces in this case to tell us one way or another how or whether the court should apportion costs of investigation or prosecution in this case. In the federal case provided, which is the Seventh Circuit Court of Appeals case from 1988, U.S. versus Piper, that court refused to allocate costs, finding that the evidence at trial or evidence adduced during the course of an investigation served a dual purpose, and therefore when that judge assessed costs, all costs, against that accused who was acquitted on some counts but not others, that was not an abuse of discretion because of the dual purpose. The cases out of Pennsylvania talk about the issue but don't necessarily help us decide how to handle it in this case. What they come down to is saying that yes, if someone is accused of multiple counts that were charged together because that's what the law required, because they arose out of the same or related criminal episodes, then apportionment is appropriate depending upon what that individual is convicted of. The case out of Wyoming, which is a lot older, 1956, Wyoming versus Faulkner, 292 Pacific 2nd, 1045, a case out of the Wyoming Supreme Court, was a situation where an individual was convicted out of, as best I could tell from that opinion, 1 out of the 47 counts of some fraud-based crimes, and that court indicated that apportionment would be appropriate unless the evidence to convict on that one count was substantially the same as for all 47, even though the individual had not been convicted. Now, what we are asking the court to do in this case is to not apportion any of the costs that have been proven here by a preponderance of the evidence as having been incurred by the Metropolitan Bureau of Investigation, the Florida Department of Law Enforcement, or the Orange County Sheriff. The first two, as I had alluded to when we started this hearing, the MBI and FDLE, had a very limited role in assisting the Orange County Sheriff in following up on leads that were generated and submitted to law enforcement agencies as a direct result of Miss Anthony's report that she had left her child with a babysitter and the child did not return, or the babysitter did not return the child. This led to the machinery, for lack of a better word, of law enforcement to engage in an all-out effort to find this child, whether that child be alive or dead, or to find out the circumstances of what happened to the child. Now, as Lieutenant Zamboras has testified, if the court wishes to accept Ms. Anthony's attorney's version, posited at trial that the child had drowned, as true, the sheriff's office would have expended next to no resource in figuring out what happened to Kaylee Anthony. Even if that involved ultimately the recovery of her remains at that time, it certainly would not have been the endeavor that had occurred back in December of 2008 in order to appropriately recover all her remains to give her a proper burial. The defense, through some of the questioning, I would suggest to the court, takes too narrow of a position as to what is the appropriate apportionment of expenses, concentrating on the fact that these lies that were charged and proven were done in short order by law enforcement. I believe that the case law, even the case law out of Florida and the out-of-state case law, suggests that costs that are causally related to the offenses for which somebody is convicted should be imposed or must be imposed under Florida statute. Therefore, it is our position that as a result of the lies that she told, the sheriff's office undertook an investigation that cost them hundreds of thousands of unnecessary dollars. And that as a result of her telling those lies, that she should bear the responsibility that the taxpayers now have to bear for the investigation into locating Kaylee Anthony, investigation into following up on leads and tips as to where she was, whether that be a live child or a dead child. Regardless of when Casey Anthony was indicted, on October 14th of 2008, Kaylee Anthony was still missing and had remained missing up until December 19th, really, which is when the medical examiner had announced that there had been an identification of the remains first located on Suburban Drive on December 11th of 2008. Once Ms. Anthony set that machinery into motion by lying as indicated in counts 4 through 7 of the indictment, there was no turning back in the investigation. She, to this day, has not given any other information about what happened to the child except that a nanny had refused to return her and she didn't know where she was. It is our position that this lie or this series of lies that led to this investigation are inextricably intertwined with the entire investigation and cannot be apportioned. There's no way to decide which facts are white and which facts are black when we all have gray. During the course of the trial, and this argument goes more towards the expenses of the Office of the State Attorney, because as the court can see from the documents presented, they are mostly deposition costs. There are witness expenses in there, and expert witness expenses, where I expect that there would be some argument that the necessity of those witnesses had nothing to do with counts 4 through 7. Counsel had argued to the jury in this case that proving that Ms. Anthony was a liar did not make her a murderer. I believe that the opposite argument is true as well, and that attempting to prove Ms. Anthony was a murderer, in fact, proved that she was a liar. That this lie that she told, which the police translated from her words into the child being kidnapped, proves counts 4, 5, 6, and 7. Based on that, we don't believe that any cost should be apportioned in this case, that it is impossible to split them and determine which in fact went to counts 1 through 3 and which went to 4 through 7, because the lies of Casey Marie Anthony infected this entire case as they do to this day.
Mr. Mason.
I think it is time that Lost Lamar's office accepts the fact that they lost this case. Casey Anthony was acquitted of all the felony charges, and she's convicted of these misdemeanor cases that deal with lying about specific things. Let's talk about what that really means. The statute in question, Your Honor, 938.27, does provide for costs of prosecution and investigation in every case of conviction, and goes so far as to describe that even means plea, trial, violation of proceedings, whether adjudications will held or not, and so forth. You read the statute. And it goes further to say that, of course, the state has the burden of proving that the costs are proper and reasonable, and the court, in essence, as I read it, should, as in all other matters, ensure that justice is done. And if there's justice in trying to charge this young girl acquitted with these outrageous expenses, then we need to redefine the books. Now, several things that I have done pointed overall for you in trying to do this, because there is no case law, as counsel says, that's on point. And we have all searched for it, and we have not found it. But what we do know is that the statute upon which Casey was prosecuted is 837.055, that says it's a crime to give false information in a missing person investigation. Not in a homicide investigation, not in a child abuse investigation, not an aggravated kidnapping, manslaughter, or any other kind of crime you talk about. It is specific to the offense of while conducting a missing person investigation. And the indictment charges in counts 4, 5, and 6 of these false statements to Yuri Millich, who was conducting a missing person investigation. Not some other related thing, not some homicide for which she's been acquitted, but a missing person investigation. Sergeant John Allen and Corporal Millich, before you in the trial, you probably remember when he was called to stand, said the same thing. They, and Millich, by the way, is the identified, I guess, quasi-victim, the way the indictment reads, testified that as of September the 30th, there was no longer a missing person investigation. It was a homicide investigation. Now, in not being able to find any case law dealing with appropriate apportionment or how you might do this, I started thinking, well, what are the increments of time that are important here? When were these expenses incurred for which the government wants to charge Casey? We know that now, from John Allen, they were no longer conducting a missing person investigation as of September the 30th of 2008. And when we started earlier today, and I mentioned to Your Honor that you had all these documents here that you can read very well, if you have some of your assistants go through page by page and look at dates per year.
Mr. Mason, my assistants don't go through pages for me.
You.
Okay.
Okay. Well, we'll do that. And if you do that, you will see, well, there's very limited expenses of a missing person investigation. In addition to that, the specifics of the indictment of conviction for which the statute applies, all the witnesses now have acknowledged they knew were false statements made by the defendant to Yuri Millich within hours. You remember the trial. 15th, the night, not there. Okay, I lied, you got me, on the 16th and 17th of the interrogation. I have to accept the fact that she's been convicted of those, even though they're on appeal. I accept the fact that I disagree with the underlying ability of that evidence, but it's been ruled on. So we move ahead. Now, so you have September the 30th as a date. Counsel has just argued that, according to Lieutenant Zamboros, if the defendant had told them the drowning scenario, they would have had only a few days. Well, guess what? A few hours ago, you allowed the questions over objection about the date of the calls of the Sheriff's Department, August the 13th, 2008, by Mr. Cronk. Had the Sheriff's Department that's seeking all this money done their job on August the 13th, by that date, they would have found the remains of little Kaylee. Let us not forget that Deputy Kane went there when Mr. Cronk had called again, and he's saying the remains were there. Let us not forget that the evidence was that was 19 feet from the side of the road, here to that wall. Let us not forget that Deputy King did nothing except slip on the grass and get mad at Citizen Cronk and attack him and not follow up. The Sheriff's Department didn't follow up at that time doing anything as of August the 13th. You've got another increment date. This is another important one when you're trying to figure out how to apportion this. The indictment on October the 14th charges these offenses and the defendant with murder, aggravated child abuse, aggravated manslaughter. Now, how can you have a legitimate claim to suggest you're looking for a missing person that you're accusing somebody in the same document with having murdered? I hear today apparently a suggestion that a missing person investigation is now, in an effort to get this money, is going to be redefined as a missing remains investigation, not a missing person investigation. As of October the 14th of 2008, it was clear, even though the detectives said they knew it on September the 30th. Now the grand jury, directed by the prosecution, has said on October the 14th that in fact it's murder charges and the child is dead. So any continuation of a missing person or claim to, Your Honor, I respectfully suggest is a fraud. A next date you may also consider is December the 11th, 2008, when the remains were found. How can someone still try to claim a missing person investigation months after the indictment and the remains are found? And when you look and consider those dates and the various stacks of invoices that have been presented, then you will be able to see and know why I made a point out of it with respect to the Florida Department of Law Enforcement, marking the dates and the pages. You made notes of that, of the cutoff dates. December the 11th, October the 14th, and now you can go back to September the 30th for John Allen. The Metropolitan Bureau of Investigation. It's a reasonably small claim in the grand scheme of things in this case. But it also includes expenses and times claimed for periods after the indictment. And if you look on their exhibit, you'll see that as well. So there's some adjustment there. I will tell you that the initial things from the FBI that they said, I do agree, are reasonably related to the initial missing person deal, because at that time they haven't made the determination it's no longer a missing person. But I want you to look also at the major exhibits. There's an inch stack of bills related to court reporters' expenses. And my review of each of these documents, which I did, and for the fact that the overwhelming majority of them, I was present, these did not occur, any of them, even in the year of 2008. These are not cost of investigation. And they're not depositions related to prosecutions for those counts of lying that were already known and established. They have charged, it would appear, a total of $46,427.78 for depositions that were done almost substantially in 2010 and early 2011. They got nothing to do with the crimes of conviction. Zero. If you look at the state's package of expenses, sir, they are charging, or attempting to charge, and have you tax Casey with expenses for all of their experts. Dr. David Hall, James Jowitz. You don't even know who James Jowitz is, but I will tell you that I don't think you do.
No,
not from this case you don't anyway.
I don't.
He is a hydrologist of the University of Florida that had done testing and test wells and various things to render an opinion as to whether or not X marks the spot off Suburban Drive had been underwater, and guess what he said? No, it wasn't. He didn't come testify. His bill's $5,750. Neil Haskell, the bug man. What has he got to do with whether or not Casey lied to Mr. Melich about her working at Universal Studios. Or that there was a Zaneta Fernandez Gonzalez, a fictional person, in Apartment 210 at Sawgrass. Or that she had a phone call from a fictional person named Jeffrey Michael Hopkins and Juliet Lewis. And or whether she'd had a phone call from Kaylee. Well now, Dr. Neil Haskell is attempting to charge here $32,072 to try to say that those are somehow legitimate and reasonable investigative or cost of prosecution expenses related to the crimes of conviction. No way. Not to be outdone, Dr. Michael Warren. He's a guy who had that let me clean up my thoughts here. He's the one who presented the superimposition photograph of the guy that you know I like so much from Gainesville. He charged $3,000 to explain it to the prosecutors, and his total bill is $12,200. Well, what's that got to do with lying about working at Universal or going to Apartment 210 or calling these fictional people or saying she's got a call from her daughter? Dr. White's $3,585. Arpad Voss. Oh my. Arpad Voss has billed the state, and the state has paid, according to my records, over $3,600 for his testimony, investigation, his testimony at the fire hearing. Judge, you got to help me out here. What's this got to do with counts 4, 5, 6, or 7, the crimes of conviction? Nothing. Then you got John Bradley, Charles Marth, who we never heard of, $6,000, John Schultz, and expenses of per diem and so forth for the 3 prosecutors. For expenses going to Washington, D.C. in 2010, and some going to Oak Ridge National Laboratory depositions in Knoxville, Tennessee, that we also did. I can't remember the date. I'm sorry. It was 2010, around September, October, November, somewhere in that vicinage. So you have the estate claiming, in essence, 100% of their expenses for the prosecution of the case that they lost. Not for expenses related to 4 misdemeanor counts. And if you look through some of these bills, sir, I can tell you that they've charged all the travel expenses and per diem stuff, and even just to blister me, I suggest, charging for Jeffrey Ashton buying a book on Amazon.com for $31.50 to have something to do with that lying.
What was the title of the book, Mr. Mason?
Well, hang on just one second. I have that.
I thought maybe you knew it.
Do what?
I thought you knew the title of the book.
I'm going to tell you. Because I got it marked. Where's my magnifying glass? I'll find another way to read it.
If you don't have it handy, don't worry about it. I was just curious.
It's a good thing I didn't have my glass because it wasn't on that page. You've challenged me. I got to find it.
It's not important, Mr. Mason.
It's in that package. I guarantee you, you'll find it. Amazon.com, $31.50, and it had to do with something to do with decomposition. So my point then, Judge, is that the state following within the wind of the outrage and the unpopularity and the prejudice against Casey, wants to charge her the entire cost of prosecution, not the legitimate expenses related to the convicted counts. That, to me, has nothing to do with justice. It has to do with outrage. It has to do with sour grapes. Don't tell me that this can be the precedent of allowing the state to charge everything no matter where they won or lost. What about the defense? What about the $2.5 million for the contributed legal time for the defense team to try to save this girl's life? What about the fact that Casey spent 3 years in 24/7 locked down, not able to work or earn or do anything? What about the loss of revenues and any money that anybody can make on that? Where is justice for the defense that won? We're now going to get whacked again, according to the theory of the state, pay for everything they did, their trips, their meals, their books, their travel, and their experts, none of which had anything to do with the crime of conviction. And that's the major distinguishing point. I ask the court to consider the outrage of that and a couple of cases. And I appreciate the prosecution's efforts. She referred to a Commonwealth v. Coder, Pennsylvania decision from 31 years ago. Actually, it was a case about change of venue costs. And they held in that position challenging or the issue of expenses regarding witnesses that were reasonably necessary to prove the charges for which the appellant was convicted. Don't have it here. And in the Piper case, talking about dual purposes, that was the case, Your Honor, of a tax conspiracy of multiple counts, that are obviously interrelated. There is dramatic distinction in our case between the allegations of lying on July the 16th while in the hearing room or an interrogation room at Universal Studio, known to them to be false within hours, and that type of case. None of the state of Florida's charges are legitimate other than the statutory entitlement of $50 for each of the 4 counts, because none of the expenses were incurred in proving the lies they already do. None of them were incurred until well after the witnesses testifying they weren't doing missing person, the indictment, the recovery, the identification, and in the next year. The other expenses of the different agencies should be related to those time cutoffs as well. The Sheriff's Department cutoff as of December the 11th time remains being found. But they acknowledged they knew it was not a missing person case as of September the 30th. So I suggest to you that at a minimum, any expenses related to the investigation up until September the 30th by the Sheriff's Department, those might be entitled, but after that, no way. And the same goes with the cutoffs for the other ones that we did with the cross-examination of the witnesses. Thank you.
Ms. Burdick, anything in addition you'd like to say?
Just very briefly, Your Honor, I don't intend to take Mr. Mason's bait or to call him names or suggest he engaged in any fraud. Nonetheless, the argument of the defense completely misses the point of my position as it relates to the costs of prosecution specifically. And that is that but for Ms. Anthony's lying to law enforcement at the inception of this investigation There would be no costs of investigation to law enforcement, whether that be the sheriff's office, FBI, FDLE, MBI, many other acronyms that we haven't discussed here. There would be no costs of prosecution for this trial and the pretrial investigation that took place. And therefore, as I had argued, every expense, regardless of how counsel wants to belittle it, is related causally, if not directly, to the machinery put in motion by Ms. Anthony. Coder, the case out of Pennsylvania, that's C-O-D-E-R, makes the following statement, which, although the facts aren't completely analogous to these, but it says, in essence, that it is neither arbitrary, capricious, or unreasonable to hold the defendant responsible for the dysfunction his, or in this case her, conduct caused the criminal justice system. And that is the point that we are trying to make. We're not trying to assuage anyone's outrage as a result of the verdict in this case, but we wish the court to give careful consideration to all of the expenses of the various agencies involved that would never have occurred if Miss Anthony had it in her to ever tell the truth.
Just a simple question from both sides. Did either side look at the legislative history of this statute and attempt to ascertain the legislative intent behind the statute?
The costs of the recovery of costs statute?
Yes.
I looked at the bill that changed the numbering, but whether or not there was any legislative history or any analysis, no, I have not.
Sometime in the bill drafting stage, they will express the legislative intent. Another issue deals with rules of construction and what was the intent of Florida Statute 938.27. Was the intent simply to lay at a defendant's feet, so to speak, solely those costs which have a reasonable relationship to what they were convicted of, as opposed to costs that deal with things they were not convicted of. Okay. When does this court lose jurisdiction, Ms. Burdick?
I believe it is September 22nd.
Yeah, I think that's what you said before.
And is the statute in the state of Pennsylvania similar to the statute that is here in the state of Florida? Are the statutes drafted the same, or are the statutes different?
I think they are different. As I recall, in Pennsylvania, their statute's been on the books since the 1800s, and there was some reference in one of the cases that said all the costs of prosecution, but the case law had defined that to say all means those causally related. I don't know that they are identical in structure.
Okay. So I have basically until September 26th.
It says response due 9/22 on the order. I don't know if that is a weekend.
That can always be extended if necessary.
Well, my problem is I start a trial period Tuesday.
Do you want briefs on those issues that you just raised?
You can submit briefs to me. I will start researching as much as I can in the evenings, but I have You have the trial calendar yet, or did she bring that up?
Judge, in answer to your one question, 938 itself is pretty clear as to case of conviction.
I know that, and that's why I asked the question about the plain meaning of the statute, and that's why I'm kind of interested in the legislative intent, because the plain meaning of the statute would have to relate to something that someone was convicted of. But
what they have done is changed it a couple of times, and it really dealt with the indigency status of the defendant, whether they could afford to pay or not.
Well, I will pull the statute from when it was originally enacted and look at the subsequent legislative changes and see. More than likely, I have somebody pull it for me to save time. Just a second. They relinquish jurisdiction from 30 days from what date?
I don't have that order yet.
I think it's somewhere in my office, and it's not in the court file.
No, I have it here. I have an extra copy for the court if you want to read
I just
that.
need to know the date of the order and how many days they gave me.
The date of the order, August 23rd, 2011. 30 days.
30 days from that date.
But I can tell you now on the record, if you felt it necessary, the defense would not object to a reasonable extension for you to finish your work. And I'm sure the appellate court will give it to you.
Just a second.
Statute was renumbered.
If you want to submit any additional briefs and authority, give them to me by next Friday.
September 9th.
Call Jill 20008 and see what's the final tally on my trials. No. The total number of trials set. All right, I got 21 trials set for a 2-week period. I think I can get it done within the time period. If not, I ask for an extension. Okay, but you have it to next Friday to get me what you need. Okay, anything else, folks?
No, thank you, Your
No,
Honor.
sir, thank you.
Okay, thank you very much, folks. Carrie? I got to sign a paper. Have the exhibits that were placed as evidence, I guess, put in a little box and sent to my office along with a copy of the amended motion.